The Supreme Court on Friday, February 23, questioned the remit of the High Court to set aside a conviction under the Protection of Children from Sexual Offences (POCSO) Act, merely on the basis that the sexual intercourse was with consent, when a minimum punishment has been prescribed under the statute for having sexual intercourse with a minor, in the absence of a constitutional mandate to do complete justice that is enjoyed by the top court. This issue was flagged by a bench of Justices Abhay S. Oka and Duj Dulbhu in hearing a suo motu writ petition and an appeal against a Calcutta High Court judgment which made news in December last year for cautioning girls in their adolescence to control their sexual urges to prevent being deemed a loser in the eyes of society or when she gives in to enjoy the sexual pleasure of hardly 2 minutes. While deciding on appeal in a sexual assault case involving young adults, the High Court had issued a set of advisories to teenagers, which included these observations. The remarks triggered an outrage and led to the Supreme Court taking suo motu cognizance in a case titled In Re, Right to Privacy of Adolescent on the directions of the Chief Justice of India. Later, a special leave petition was filed by the state of West Bengal challenging the verdict on its merits. In December last year, while issuing notice to the state government, the accused, and the victim, the top court observed that these remarks were highly objectionable and completely unwarranted, besides being in violation of the rights of adolescents under Article 21 of the Constitution. In an appeal against conviction, the High Court was called upon to decide only the merits of the appeal and nothing else. Prima facie, we are of the view that, in such a case, the judges are not expected to either express their personal views or preach, the bench noted in its order. Asking the state whether it intended to file an appeal against the judgment, Justice Oka also orally remarked that even the merits of the reversal of the conviction seemed doubtful, although the issue was not within the scope of the suo motu case. Subsequently, the state of West Bengal challenged the controversial verdict in a special leave petition, questioning the merits of overturning the conviction under the POCSO Act. Directing West Bengal's plea and the suo motu petition to be heard together, the bench said that not only were the observations in the High Court judgment problematic but also the legal principles invoked in it. The Calcutta High Court, in the impugned judgment, exercised its powers under Section 482 of the Code of Criminal Procedure after noting that the lack of recognition of consensual sexual behavior of older adolescents has resulted in their automatic criminalization, as well as a conflation of consensual acts with non-consensual acts. The High Court took into account the fact that the victim married the convict and that a child was born in the relationship. This is not the first time a High Court has taken a liberal view with respect to the age of consent. In 2021, the Madras High Court quashed the criminal proceeding initiated against an accused under the POCSO Act on the grounds of an amicable compromise of the disputes between both parties. Punishing an adolescent boy who enters into a relationship with a minor girl by treating him as an offender was never the objective of the POCSO Act, the High Court observed. Last year, in February, the Meghalaya High Court quashed criminal proceedings under the POCSO Act on the ground that the victim was in an intimate and consensual relationship with the accused and both have agreed to stay together as husband and wife. In March, the Bombay High Court followed suit, quashing a first information report (FIR) registered against a 19-year-old boy under the Indian Penal Code and the POCSO Act for the alleged abduction and sexual assault of a minor teenager. Later in the year, a single-judge bench of the High Court expressed concerns about the increase in criminal cases involving minors in consensual sexual relationships, calling for a shift from a punitive approach towards adolescent sexuality to one that enables access to sexual and reproductive health services. Similarly, the Madhya Pradesh High Court also quashed a rape case against a POCSO accused, noting that the complainant, a girl on the cusp of legal adulthood, was capable of making conscious decisions regarding her well-being. In August, the Delhi High Court quashed a POCSO case noting that the victim was happily married with the accused and the former's father had lodged an FIR against the latter in a bout of anger. Some other high courts have taken a strict view that the consent of a minor is irrelevant under the statutory scheme and imposed the minimum mandatory sentences on the accused. However, the Law Commission in its 283rd report on the age of consent under the Protection of Children from Sexual Offences Act, 2012 noted that blanket criminalization of sexual activity among teenagers under the POCSO Act was a cause of concern, while cautioning against a reduction in the age of consent to 16 years or carving out any exception for older adolescents, which, according to this report, could lead to an increase in child marriages. The Commission suggested granting judicial discretion to court to impose less than the minimum sentence where the victim is above the age of 16 and the age difference between the persons is not more than 3 years. Courtroom exchange. Today, the bench granted leave in the special leave petition filed by the West Bengal government and directed both the matters to be listed for final hearing on Thursday, May 2, after senior advocate Hoseifa Ahmadi, representing the state, told the court that service was complete. It also permitted written submissions to be filed by the state government, the amicus curiae, and the accused. In view of senior advocate Liz Matthews' recent designation as a senior counsel, an advocate on record was also appointed to assist her and senior advocate Madhavi Devan, the two amicus curiae appointed by the court. We will examine both the questions, first being the merits of the acquittal, and the second with respect to the other aspects, Justice Soka indicated. In response to this, the counsel appearing for the accused raised concerns over the impact of setting aside the High Court's acquittal order on the victim, who according to him, was living with the accused and had a 2-year-old child with him. If the impugned order is set aside and conviction is upheld, unfortunately, it is the victim who will suffer the most. The accused is married to the victim and they have a child staying with them. The accused is taking care of both the victim and the child. The victim herself appeared before the High Court and admitted to being married to him. They are from a remote village in West Bengal. The judge explained that the Protection of Children from Sexual Offences Act prescribed a minimum punishment for sexual intercourse with a minor. He added, the first question is whether the High Court can overturn the conviction, contrary to the statutory provision. It has no powers similar to Article 142 of the Constitution. I am on a more compassionate ground rather than on merits today. I'll address the court, the counsel replied. Another issue that troubled the bench today was the non-appearance of the victim, which was flagged by the state government's lawyer. Ahmadi suggested the issuance of bailable warrants under the Code of Criminal Procedure to compel her presence in court. The counsel appearing for the accused, however, objected. He told the court, I will seek instructions and persuade her to appear, because she is staying with him. It is pointless to issue bailable warrants for her. I will persuade her to appear. I will put in my work out on her behalf. To this, Justice Soka said, her presence will be required. What is the difficulty in appearing before the court? We'll post it on a day only for that purpose. We'll not issue warrant but somehow procure her presence. Accordingly, before adjourning the hearing, the bench added to its order, only for the purposes of procuring presence of the victim, the petitions shall be listed for directions on March 7. Background. The controversy has erupted over certain observations made by a Calcutta High Court bench while overturning the conviction of a 25-year-old man accused of having sex with a minor. These observations have been excerpted below. It is the duty or obligation of every female adolescent to I. Protect her right to the integrity of her body, 2. Protect her dignity and self-worth, 3. Thrive for the overall development of her self transcending gender barriers, 4. Control sexual urge or urges as in the eyes of the society she is the loser when she gives in or enjoy the sexual pleasure of hardly 2 minutes, v. Protect her right to autonomy of her body and her privacy. It is the duty of a male adolescent to respect the aforesaid duties of a young girl or woman, and he should train his mind to respect a woman, her self-worth, her dignity and privacy, and her right to autonomy of her body. The judgment delivered by the High Court on October 18 came in an appeal by a young boy sentenced to 20 years in prison for the offence of sexual assault under Section 6 of the Protection of Children from Sexual Offences Act and Sections 363 and 366 of the Indian Penal Code. While acquitting the appellant, a division bench emphasized the absence of provisions in the POCSO Act for consensual, non-exploitative relationships between adolescents aged 16 to 18. Citing the principle of Dharmo Rakshati Rakshayut AA, one who protects the law is protected by the law, From the Mahabharata, the High Court outlined specific duties for adolescent boys and girls. It highlighted the duty of females to protect their rights to body integrity, dignity, and self-worth, urging them to transcend gender barriers and control sexual urges. The male adolescents were directed to respect these duties, training their minds to respect women's self-worth, dignity, privacy, and autonomy. In this judgment, the High Court delved into the biological explanation for sexual urges in adolescence, emphasizing that while libido is natural, sexual urges depend on individual actions. It deemed sexual urges abnormal and non-normative without commitment or dedication. It noted we do not want our adolescents to do anything that shall push them from the dark to the darker side of life. It is normal for each adolescent to seek the company of the opposite sex, but it is not normal for them to engage in sex devoid of any commitment and dedication. Sex shall come automatically to them when they grow self-reliant, economically independent and a person which they dreamt one day to be, it concluded. In December, the Supreme Court took suo cognizance of this Calcutta High Court judgment. Last year, in June, the top court had also acted on its own motion against an Allahabad High Court order directing the examination of a woman's horoscope to determine if she was a Manglik. Case details. In Re, Right to Privacy of Adolescent, SMW, Civil, No. 3 of 2023,